Hi everybody, this is Marisa Portuondo and this is day 4 of our litigation series. Now, I wanted to talk to you guys about the other responsive option that's available to defendants once they've been sued, and that is the motion to dismiss. But I realize that most people who don't work or live in the whole legal system and maybe aren't related to lawyers or aren't lawyers probably have no idea what a lot of this legal jargon means, so I decided to back it up so that the videos wouldn't get too dense and too long. And for that reason, I actually want to talk to you about what a motion is, so that tomorrow when I talk about a motion to dismiss, you will understand a little bit better what's going on. Now, in court, or I should say in litigation, a motion is how a party, and that's either the defendant or the plaintiff, gets something from the court. And basically the lawyer will write the motion, the lawyer representing the party that needs whatever they need from the court, and then they will file it. And as soon as they file it, the other side should get served. Back in the day we would have to mail it. Now we have electronic service, which is a lot easier. So usually that gets electronically filed and the court gets a copy and the other side gets a copy. Sometimes we have to electronically send it to the judge separately. Now, when that motion gets served on the other side, it's very common for attorneys to call each other and try to work it out. Sometimes it's required that we try to do that prior to going up in front of the judge. If the attorneys cannot work it out, then it is set for a hearing. And what a hearing is basically what you see on TV all the time. It's two attorneys standing in front of the judge, arguing over a motion. Now, as the moving party, which is the party who filed the motion, you usually go first. You argue your points. The other side will argue against it. There's some back and forth. The judge asks questions sometimes, and then the judge will decide on the motion. Now, what the judge's decision is called an order. So the judge will actually write the order, or sometimes the lawyers will write it for the judge according to what the judge dictates, and then the judge will sign that order. Once that order is signed, it becomes part of the record, and the order will clearly state, whether the motion is denied, whether it's granted. Sometimes it's granted in part, denied in part, and it'll say which parts of it are granted and denied. It's very common for attorneys to work things out, especially if the relationship hasn't soured. We always try to get along as well as possible with our opposing counsel for this reason, because it does save time, it saves our clients money, and it helps things to move along faster. Now, when that happens, what happens is that the two attorneys will actually write a proposed order, and they will submit that to the court, letting the court know, hey, we actually worked this out on our own, and this is our proposed agreed order. And I don't think I've ever had it in my career where the judge says, no, I'm not going to enter it, because the judge is usually just happy to get it off his or her desk. There's no decision to be made. The parties have come to an agreement. So that's a brief summary on what motions are, how they work, how they move through the court, and what the order, which is the judge's decision, is, and how that affects things. All right, tomorrow we will talk about the motion to dismiss. Have a great night.